Welcome to today's session, Coronavirus-Related Legal Questions. It is my pleasure to turn it over to our session presenter, Ed Easterly, Esquire, of Hoffman, Hlavac, and Easterly. Ed?
Hi, thank you. Hold on one second. I gotta share my screen. There we go. Hopefully everybody can see me, or not me, but my screen. I thank everybody for attending today. This is a different world we are living in. I would have much preferred to present a different seminar to everyone at the conference, but this is where we are. So what I'm going to go through in the next 30, 45, 50 minutes, depending on how long I talk. I am a lawyer, so I don't hate talking. I'm going to go through issues related to the coronavirus that are facing employers, employees, that we've seen in the last few months develop, and that we believe the information is beneficial for you to know, to again, not only share with your companies if you're an employer, but to share with students or if you're a career service person, representative, to make sure they understand what their rights are. They understand what an employer's obligation is, so they make sure they feel safe in the workplace, and if there are issues, what they can do to protect themselves. We're going to go through a lot of information today. This seminar could probably be 5 hours long, but it's a lot of information that you need to understand, because what we are seeing are a lot of legal landmines, lawsuits, discrimination claims. And as we're going through this, there is a chat screen that you can pose questions in as I'm talking. I'm not going, usually when I'm giving a seminar, if anybody's ever been to one, I stop and answer questions as I'm going. With these Zoom sessions, I believe it's easier for me to just talk, and then at the end, I'll answer as many questions as I possibly can. If we don't get to all of the questions, we'll figure out a way to get you all answers. But what we are seeing today are lawsuits, wrongful termination, wrongful death, issues with OSHA. People aren't handling the health and safety requirements that they need to appropriately. There's unemployment compensation concerns, right? Do I get to collect here? Do I not get to collect here? When do I get that extra $600? If I refuse to come to work, or if I have an employee refuse to come to work, what are my rights and what are my remedies? These are all issues that employers and employees are facing at this point in time. And it is a confusing time for everyone, and it's a scary time for everyone. But both employers and employees need to understand that, yes, there are new laws that we have to adhere to, but the old laws are still in place as well. We still have the applicability of the Fair Labor Standards Act, which deals with wage and hour issues, the Family Medical Leave Act, which applies for a leave in certain circumstances. Employers still can't discriminate against employees based upon their race, their national origin. Now it's been actually recognized sexual orientation and gender identity is included in that. These are all things that employers still need to comply with, and employees still have protections. But we've seen new issues arise. There's new laws. The Family First Corona Response Act, we're going to get into some of those requirements today, so you understand what it provides for and what employees are permitted to do. What have we seen a lot of? And it's the second bullet point, are Google-based lawyers, right? There's a lot of people have free time on their hands. So employers, when they want to do something, are getting a response from employees of, well, I searched this and this is what my rights are and this is what your responsibilities are. And that's fine. But from an employer's perspective, they don't have to go by what the employee says. And if you are telling your students something, what I would make sure they understand is not everything they read on the internet is likely to be accurate. If they are going to tell their employers that they can take leave here in this situation because of this reason, they better be right, or else they're making an argument to their employer that could potentially get them into problems. So what are we going to talk about today? We're going to talk about offers, pre-employment stuff, pre-employment issues, recalls to work, what employers should do, what employees should expect, what applicants can expect when being recalled to work in this coronavirus world. What happens if an employee refuses a recall? Can an employee refuse to come back to work? Can an intern or a student refuse to come into the workplace? Unemployment related issues. This pandemic response plan, what are employers required to do and what should they be doing to protect their employees when they come into the workplace? We're going to discuss dealing with employee health issues, dealing with pay issues, and liability problems and liability concerns from the perspective of a college and an employer. These are all issues that everybody is dealing with today. And every state where I know from doing these long enough, there are people on this call from probably every different state in the country, and every state is handling this in a different manner. Right? Every state has different rules for opening up. I'm in Pennsylvania. We have phases. I am currently, as of today, in what is referred to as the green phase. So if I want to, I can actually walk into a restaurant, right? But every state is opening up in a different manner. So we need to make sure that we're complying with the requirements of the state's orders from their Department of Health or their governors, in addition to whatever the federal laws are. So the first thing we're going to discuss are pre-employment issues. And there are a couple things we want to focus on here. The first question I want to answer is, can an employer delay an offer due to COVID? What do I mean here? Well, let's say that a company is not open. They shut down because of COVID-related reasons. There was a shutdown in our state. We still haven't reopened. A lot of companies are not reopening yet that we do business with because they don't want to reopen, even if they're allowed to, because of COVID-related concerns. So can an employer delay providing an offer at this point in time? Can they delay the start of a job? Okay, let's say, for example, I'm supposed to start for company ABC on Monday. And my ABC contacts me and say, listen, due to COVID, we're not going to be able to start you until September. Is that okay? Does that company have to pay me for that time? Well, the answer to the first question is yes, that's okay. You are permitted to delay an offer due to COVID-related reasons. And there is no requirement that I compensate that individual during that period of delay. Employer is more than welcome to do so, but there is no legal requirement that I pay somebody before they actually start to work. What about this second bullet point? Can an employer withdraw an offer due to COVID-related issues? That's also generally yes. There are some wrinkles, right? And there's some specific questions that apply here. What if I test positive for COVID? I'm supposed to start, again, let's use my example on Monday. I'm supposed to start this job on Monday. I call my employer, my potential new employer, and say, listen, I just found out I tested positive for COVID. I'm going to have to be quarantined for at least 14 days. I don't know when I'm going to be able to start. Can that employer say, unfortunately, we need somebody on Monday, so we're going to withdraw our offer? Can they do that? The answer to that question is yes. Usually I would like to throw that question out there and get responses, but I'm just going to answer my own questions for the majority of this. The answer to that question is yes. Right? An employer can withdraw an offer in that scenario. If somebody has a positive test, if they're quarantined, if they can't start when they are supposed to start, if their starting date is going to be delayed due to no fault of the employer, the potential employee, the applicant can't start because of this COVID-related issue, then yes, an employer can withdraw that offer. The EEOC, the Equal Employment Opportunity Commission, has specifically come out and said that that is an acceptable reason to withdraw an offer. What about this pre-employment testing? Employers are allowed to conduct certain post-offer pre-employment testing, medical testing. This would generally include drug tests, right? Or physicals to ensure that somebody is able to perform the essential functions of a job. You can now include the COVID testing in this pre-employment testing. And we're going to talk in a little bit about antibody testing. That would not fall in here because antibody testing is generally not recommended. But if you want to make all of your employees have a COVID test before they start, that is acceptable. If an applicant, if one of your students comes to you and says, listen, this Ed Easterly from Hoffman, Hlavac and Easterly wants to make me take a COVID test before I can start work, I don't want to do it. Is that okay? If you reject it, if you have an applicant reject it, they can lose their ability to have that job. So this is something that is permissible in the employment realm. It is now a new pre-employment, post-offer pre-employment test that employers can use. So those are some of the pre-employment issues we're seeing: delays, withdrawals, testing. What happens if we already have employees working, or I'm supposed to start and I have a medical condition that requires me to work from home? Can an employer require their employees to physically come to work? The general answer to that is yes. Again, it depends on where you are, number one, and what phase of opening you are in your state, but I'm just going to talk in generalities. If your business is open pursuant to your state rules, your state laws, and you are allowed to be in your place of business, then an employer can generally require employees to come to work. There is no legal requirement that they be permitted to telework at all points in time. There are some wrinkles, right? There are specific factors that may come into play if employees request to work from home. Let's say I have been working from home for the last 3 weeks. I have a medical condition. I have asthma or some other medical condition that puts me at risk. I'm recalled by my employer, and I contact my employer and say, listen, I can't come back to work. I have a medical condition. I want to work from home. Well, the employer then has a responsibility to engage in what's the Americans with Disabilities Act, the interactive process, to determine whether or not that's a reasonable accommodation. And what factors can the employer consider? Well, is the job supposed to be performed at home? Right? If I'm a janitor, I can't really clean the building from home. That's the first factor that should be considered. Most businesses, when this all happened, tried as best they could to let people work from home just so they could continue to have some sort of operations. However, the employers can now look back and say, well, was the employee actually working? What kind of productivity occurred over the last 12 weeks? We can conduct an evaluation. We just had a client who had a similar situation. They have 2 employees who wanted to continue to work from home for whatever reason, and they looked at their productivity when they were actually in the office and compared it to what they did when they were at home, and they were doing about 5% of the work at home that they were doing when they were in the office. So the employer looked at that and made the determination that they have to come to work. But the employer at least has to engage in this interactive process to determine whether or not it's a reasonable accommodation to allow somebody to continue to work from home. Because teleworking can be a reasonable accommodation under the law, but we have to look at all of those factors. We have to determine whether or not this position can be done at home. What are the supervisory issues? What's the compensation issues? These are all factors that need to be taken into account. But the general answer is, can an employer say, yes, you need to come back to work because you're required to do your job in our office? Yes, that is something an employer can do. Those other factors need to be taken into consideration if an employee brings up issues that need to be addressed. Who is going to get recalled? Right? Employers made a decision. We're opening back up. We want everybody back in the office. We've been shut down. Who is getting called back to work? Those decisions need to be based on objective criteria. It's not eeny, meeny, miny, mo. It's not we like Ed, we don't like Steve. We like Ed, we don't like Ashley, right? It has to be based upon objective criteria. Tenure with the company, documented performance-related issues, documented disciplinary issues. We need 10 people to come back. We're going to bring back and we have 20 employees, so we're going to bring back the 10 most senior employees. Or we need 10 people to come back and we have 20 people we're we're looking into. We're going to base it off of multiple factors: tenure, documented performance, documented discipline. All of those things are fine, but it needs to be objective, documented criteria. So there is no issue with an employer's decision making. It is not an excuse to, as we say, clean house. It's not an excuse for an employer to get rid of employees that they wanted to get rid of before. What that means is, if you wanted to fire me in February and the coronavirus hit and everything shut down, and you just put me on unpaid leave, I was furloughed, you can't now say, well, we fired you, we want to get rid of you because of your prior performance issues. I should have been fired before. It's not a reason to clean house. We have to document our decisions as an employer, and as an employee, these are factors that you need to understand go into the decision-making process. An employer also cannot single people out because of their perceived risk. An employer can't say, well, we're not going to call back Ed because I know he has a compromised immune system. We're not going to call back Steve because he's over the age of 60. It's not an employer's decision to indicate who is able to return to work. If we recall somebody as an employer and then they indicate that they have a compromised immune system or they're at risk due to their age, then an employer has to, again, make the determination of how to handle that situation. But it's on the employee to bring that issue up, not the employer to make that decision on behalf of the employee. Those are the factors that go into who's getting recalled. Those are all the things that need to be decided by an employer when we're saying, okay, we need 10 people back in the office, who's coming back? Once that happens, we need to make sure, again, everything's documented, because what is occurring now, what we are seeing are claims of discrimination being brought by employees when they are not recalled. Age, race, gender, national origin, sexual orientation, gender identity, all of those things are protected classifications that can rise to a cause of action for discrimination. The bigger issue that we have currently seen is not this specific discrimination to an individual, but the process is discriminatory. We had a client recently provide us with what they used to assess people who were going to be called back and who weren't. And one of those factors was physical capabilities. And it's just an arbitrary, do you think this person has the physical ability to do the job? That question may result in an abnormal number of older workers being separated. So again, we need to look at our process, make sure that the information we are using doesn't have an impact on a certain classification of employees. These are all factors that go into deciding who's going to come back and how we're going to come back. Now, an employer has decided who's coming back, how do they do it? They should use recall letters. Employers should be sending out these recall letters which indicate, hey, we're opening back up, or we've been open, but we need you back in the workplace. You need to come back on July 6th. You're going to be brought back to your same position, same rate of pay. If there are changes, that should be documented in it. All of that information should be specifically spelled out in this recall letter. The recall letter should also include a copy of this pandemic response plan that we're going to talk about. So employees completely understand what an employer is doing to protect them if they are required to come back into the workplace and have interactions with other individuals, not only their coworkers, but third parties, clients, students, vendors, all of those people. What are we doing to protect our employees? What rights do employees have in that plan? That recall letter needs to document all of that information so they understand what they are coming back to. If there are new policies, if there's new procedures, that should all be documented in this recall letter. While it's not in here, the recall letter is also important, just so everybody understands, if your organization received money under the Paycheck Protection Act, under that CARES Act. If your organization received that money, we have to do recall letters so it will not impact the forgiveness amount. And I am not going to get into a whole lot of PPP stuff because I said this seminar could be a few hours by itself. If we start talking about PPP information, this is going to go for 4 days. So, but the issue of importance here is that you need to have that recall letter for purposes of PPP forgiveness. So now an employer is trying to recall employees. They've sent the recall letters. Employee gets it. What can they do? Can an employee refuse to return to work? There's certain situations we're going to go through and the issues that arise because of those situations. The first situation is I get the letter. I don't want to come back because I'm afraid. It's a generalized fear. It's not as a result, I'm not sick. I'm not high risk. I'm afraid. And that is a response that we are getting from a lot of individuals when they're being recalled to the workplace. I don't want to come back to work until there's a vaccine. I don't want to come back to work until we are in this, there's a phase where there's no risk of me getting sick. I don't want to come back to work until I don't have to wear a mask. These are responses that we've been getting from employees when they've been getting recalled. I'm just generally afraid. And that's not a judgment. That's a acceptable response to this. But from an employment perspective, is that a reason to refuse work? That goes to everybody's individual determination from a business perspective. From a legal perspective, there's not any general protection for just being afraid. If an employer has done everything that they are supposed to do, complied with all CDC guidelines, state guidelines, OSHA requirements to protect the employee, and the employee still doesn't want to come back to work because they're afraid, an employer can provide a leave of absence and say, listen, we'll give you another month to see where you are, let us know, but there's no requirement they do so. An employer's response to that could be, well, we need you back at work. Unfortunately, we're going to have to separate your employment. And if an employee is just refusing available to work, it may impact their ability to collect unemployment. Because as a general matter, you have to be able and available to go to work in order to collect unemployment benefits. If you are essentially removing yourself from the workforce, you are generally not eligible for unemployment benefits. So that's the afraid situation. This situation is much more risky for employers with how they handle it. And I touched on it briefly before, but I want to go into more detail. If I'm recalled and I say I can't come back to work because I have a medical condition, what is the employer's response? The employer has to engage in the interactive process. Number one, that's under the ADA, the Pennsylvania Human Relations Act, the New Jersey law against discrimination, Florida law against discrimination. Most states have their own individualized laws against discrimination, which require employers to engage in the interactive process if there's a medical reason somebody can't come back to work. I have anxiety, I have depression, I have an underlying condition that won't allow me to return to the workplace. If I get what the employer responds to that, if I say that to the employer is, number one, you have to provide me with documentation to support that request. That's number one. Once an employer gets that documentation, they make a determination as to how to accommodate that request. If the employee cannot work from home, then they maybe have to go on a leave of absence, paid or unpaid. That's up to the employee and general state laws. If an employer has 50 or more employees in a 75-mile radius, they may be governed by the FMLA. If they're governed by the FMLA, that employee may be entitled to leave under the FMLA. But those are things that have to be worked out once an employer gets that information. So if I'm an employee and I have an underlying health condition, if you have a student who comes to you and say, listen, I can't get back to work, or I can't go to this internship because of my underlying health condition, they need to understand that they are going to be asked for documentation to support that. So that should be the first thing that employees lining up is documentation to support that request. Once that documentation is received, then the employer has to engage in that interactive process and determine what is a reasonable accommodation. The next issue that we've been seeing is I can't come back to work because my spouse, my child, I live with my parents, they have compromised immune system. They are at risk. So I can't come back to work due to that reason. What happens in that situation? Well, there is no generalized protection. This is different than if I have a medical condition. The ADA, and I would say the majority of states, do not have protections where I have to accommodate as an employer somebody else's medical condition. I have to provide you with leave because somebody else has a medical condition that puts them at risk. There is no general requirement that an employer has to say, okay, well, you don't have to come back to work because your spouse, son, father, significant other, whoever you live with is at risk. That, again, may be an employer's determination if they want to say you can take additional leave, but there's no general legal requirement to that. As you can see here, again, we talked about the FMLA, that may kick in. If the employee is needed at home to care for that person, then there may be an FMLA qualifying event. But just because they don't want to put that person at risk, there's no generalized legal protection for that where an employer needs to provide them with that accommodation. And I'm not saying an employer can't do it. My job is to tell them what the law is, and there's no legal requirement that that leave is provided. The other factor here, and I'm going to talk about this FFCRA in a second, is that if an employee can't come back to work because a family member has COVID, actually has the illness, and they have to care for them, there may be some leave that's provided by the FFCRA. But as a general matter, that doesn't kick in this situation. Child care issues. Employee can't come back to work because they have child care issues. And I'm going to go into, in a minute, a lot more detail about the FFCRA. But I just wanted to touch on what the FFCRA is at this point in time. What is the FFCRA? The FFCRA, the Family First Corona Response Act, it applies to employers that have less than 500 employees. This is a new law. This is a new requirement. This went in during the pandemic. The FFCRA provides leave for employees in certain situations for qualifying events. There's two different buckets, right, under this FFCRA. The FFCRA provides for emergency paid sick leave. That's the first bucket. And that provides for up to 80 hours over the course of 2 weeks for employees for 6 qualifying events. Those 6 qualifying events are if I have COVID, if I'm quarantined as a result of COVID, if I have to care for somebody who is sick or quarantined, or if my child care provider or school is closed. Those are the 6 qualifying events under the emergency paid sick leave. For the first 2, if it is directly related to me, I get 100% of my pay during the course of those 80 hours over 2 weeks. The remaining reasons, I get 2/3 of my pay, up to $210. If it's directly related to me, it's $500. That's the emergency paid sick leave. The other bucket is the emergency FMLA. This is different from the regular FMLA. It falls within the FMLA, but it doesn't change what the FMLA is. This emergency FMLA, this EFMLA, only has one prong, right? And again, it applies to, has under 500 employees. Emergency FMLA applies only for child care related reasons. That is it. And it grants an employee 12 weeks of leave. The first 2 weeks are unpaid, but the employee can use that emergency paid sick leave. So that means that an employee generally can get 12 weeks of paid leave for child care related reasons. That's the FFCRA. And again, we could get into a lot more detail with the FFCRA, but I wanted to provide the generalities of it. That provides this new bucket of leave. There is this small business exception for the FFCRA. If an employer has less than 50 employees, the child care reason may not apply. If it would be detrimental to the financials of the business, the employee has a special skill set, or there's not enough employees if you grant the leave. But as a general matter, that's where the paid leave under the FFCRA comes in. If somebody requests leave under the FFCRA, the employer should request certain documentation specifically related to the child care reason, that the child care provider is unavailable. The school is closed for COVID-related reasons, not because of the summer. The child care provider is closed or unavailable due to COVID-related reasons. That documentation could be requested and then provided by the employee. That's the FFCRA. If the FFCRA is not applicable, meaning you have more than 500 employees, the small business exception applies, then the employer makes a determination as to whether or not they are going to grant the employee leave under their policies, under their procedures, however they want to grant it to cover those child care related issues. That's the child care related issue, right? An employer or employee may request leave for child care related reasons, but for the FFCRA, it has to fit in that specific box. If it doesn't fit in the FFCRA, then it goes to whatever the employer's policies are or procedures are to determine whether leave is applicable. The last reason that we have been seeing for I don't want to come back to work is there's this extra $600 that have been granted by the CARES Act, and a lot of employees are making more money collecting unemployment than they were working, which is a great benefit for those individuals during this period of time. That runs out the end of July. Most employees aren't saying this, but we have had employees say, well, I'm making more staying home and collecting unemployment than I would working for you, so I don't want to come back to work. That is not an acceptable reason to refuse to return to work in any way, shape, or form. If an employee refuses solely to collect unemployment, they are removing themselves from the workforce. Employees and employers need to be mindful of that. That should not be the reason that we're refusing to return to work. If that happens, they may actually lose their eligibility for unemployment benefits. There are different procedures in place in different states to report that to unemployment so that the individual is no longer eligible for unemployment benefits in that situation. I know I've touched on this repeatedly and I keep bringing it up, and now I want to get into more detail about what it is. Employers have to have a plan in place to inform their employees what they are doing to protect them when they come back to the workplace. This pandemic response plan. It shows the employees what they are doing to protect them and provide a healthy and safe work environment. It should include state requirements, CDC requirements. We're going to get into some of this information right now. But what this does is make sure employees understand that employers are doing what they can to keep them safe and provide them with a healthy and safe work environment. The CDC guidance, what is that? Well, a lot of it's what we've been taught since we were in kindergarten. Wash your hands, cover your mouth, don't pick your nose, do things that you should have been doing to be clean 8 months ago, let alone now. Avoid contact with sick people. If you're sick, stay home. Practice social distancing. We're going to get into the mask requirements in a second, but more and more states are adopting this requirement that you have to wear masks. I know some people don't like it. Some people aren't thrilled with it, but more and more states are requiring it. Clean and disinfect surfaces. All of this sounds somewhat like common sense, but it needs to be documented in this plan, and employees should be told to do it, and employers should ensure that it is happening because this is what is protecting employees. Employers should be regularly cleaning and disinfecting high-touch areas, possibly, again, depending on your state, requiring employees to wear masks. I'm in Pennsylvania. If you go to work, you have to wear a mask unless you are in an enclosed space, you have a health or safety issue, or you're eating. Otherwise, you have to wear a mask. Practice social distancing. Limit non-essential visitors. There should also be specific protocols in place that employees are told if they become symptomatic or exposed to a case of COVID. What should happen in that situation? That should be specifically laid out in this plan. If there is a workplace exposure, what should you do? What should be included in that plan? That person should be sent home, all right, 100%. And then an employer should generally shut down that area for the period of time it takes to deep clean any locations that have been exposed to that COVID-related issue. Right? All of that should occur, and all of that should be spelled out. If you want to implement pre-shift temperature screening, you may do so as a general matter. Different states have different requirements when you have to do it, but an employer is generally permitted to do it at this point in time. So these are all facts that should be laid out in your plan so employees know everything that an employer is doing to protect the employees. And if an employer isn't doing this, if you have a student come to you and say, my employer is not doing any of these things to protect me, what can I do? Well, they can be reported to OSHA, number one. And then OSHA conducts an investigation to determine whether or not they're complying with the requirements. They can potentially be reported to whatever state agency. Again, I'm in Pennsylvania. Pennsylvania Department of Health has adopted this website where employers can be reported for not following the requirements. There are protections. If somebody is exposed to COVID, can they continue to come to work? Well, the CDC has come out and said, yes, this has changed. And again, things change. They keep changing. It's a moving target. Every time we think we have everything under control and understood, something different happens. Spikes happen. It's like Charlie Brown trying to kick the football. Lucy keeps moving it, right? Every time you think you know where we are, we're going to kick that field goal, they pull the football, and we have to learn something new. And we have to understand what we have to do as employers, as we have to understand what our rights are as employees. This is one area that has changed. When this all started, if you were exposed, you have to quarantine. The CDC has come out and said, listen, if you're exposed, you can keep coming to work as long as you are asymptomatic. You should check your temperature, self-monitor, wear face masks, practice social distancing, but you could keep coming to work. That's changed. That's the minimum requirement. Again, as an employer, you can adopt more stringent requirements. You can tell people they still have to quarantine, but that's the minimum requirement that the CDC has identified. If an employee is symptomatic, they need to be sent home, seek medical treatment. They can be permitted to work from home if available. The biggest thing is that employees, vendors, customers, anybody who is in contact with that individual needs to be notified. And when I say notified, it's not, hey, Ed tested positive for COVID, we wanted to tell you. The notification is we had an employee test positive or was exposed to COVID. You potentially interacted with that individual. We wanted to let you know. If you become symptomatic, you may want to seek medical treatment. Again, an employer can say, we are requiring you to quarantine for 14 days. It's a general notification. An employer cannot provide medical information about an employee to anyone else. So you cannot identify that individual by name. A student's name cannot be disclosed. It has to be generalities. That's the biggest thing, the notification process. How are we going about as an employer notifying other people of that information so they are aware of what steps they need to take to protect themselves and others? This plan needs to be tailored based upon your businesses and the state law requirements. And there are different requirements for childcare, retail, construction. Not one plan fits all. It needs to be specifically tailored, and employees need to be provided with this information. So again, they understand what an employer is doing to protect them in the workplace, so they are comfortable coming back. And if they're not comfortable coming back, why? If an employer is not adhering to these things, what are employees' rights? to protect themselves. Again, the number one thing they can do is report it to OSHA. The temperature check issue is one that keeps coming up. And are employers currently allowed to take temperature checks? They are. The EEOC has come out and said that during the pandemic, employers are permitted to take the temperature of employees or visitors when they are coming into the workplace. But there should be a procedure in place as to how that's going to occur. There is generally no requirements done by a medical professional, but it also shouldn't be done by somebody's coworker, so I'm getting access to medical information. It at least should be a supervisory employee who is conducting this test. And as this indicates, we can't just take the test of people who we think are high risk. If an employer is going to take the test, the temperature of employees and individuals when they come in, it needs to be done uniformly to everybody who's coming in. If somebody refuses to have their temperature taken, they should not be permitted access into the building. The results of that test need to be kept separate and confidential. It shouldn't be just put into an employee file and said, okay, Ed was fine today. But this is now permitted. 6 months ago, it wasn't. You couldn't take the temperature of somebody when they walked into your building because it's a medical exam. But this is one area where the rules have changed to protect employers and the other employees in the workplace. Do employees have to be paid to stand in line? Well, again, it's fact sensitive. If the employer doesn't know what they're doing and somebody has to stand in line for 40 minutes to get their temperature checked, that's likely to be compensable time. If it takes 40 seconds, that's likely to be what's referred to as de minimis and not compensable time. The other thing that employers are doing now is this symptom questionnaire. When employees walk in, before they can come into the workplace, they have to answer certain questions. Have they been exposed? Have they been tested? Are they symptomatic? Employers are, again, allowed to do this. This is a different standard than was applicable 6 months ago. These are questions we generally wouldn't ask to people because it's medical information. If you ask these questions, again, you have to ask them to everybody. There is this direct threat exception to the law, where if you think somebody is a direct threat to themselves or others by entering the workplace, you can treat them differently. And a lot of employers are saying, well, this is where we use our high risk. Ed, we know Ed's 65. We know Ed has an underlying health condition. So we're only going to ask Ed these questions. I would not recommend doing that. And if you have a student who comes to you and says they're being singled out, they are potentially being subjected to discrimination under the law. Employers need to be uniform in how they are utilizing these processes. Viral and antibody testing is another big issue that's come up. Everybody wants the antibody test to show that they've had it and they can't get it again. And employers requiring people to undergo these tests before coming to work, before starting work, to show they're immune or their issues. Well, yeah, a big one. The EEOC has come out in the last week and a half and said an employer cannot mandate antibody testing. They can't require it. Why? Because it is not reliable. The viral testing, the actual test to determine whether or not somebody is sick, is acceptable. But this antibody testing is not a permissible test because there is no indication that it is actually reliable and the results can actually be utilized. The mask issue. A lot of people don't want to wear a mask because it's impacting my constitutional rights. I shouldn't be forced to wear it. That's an issue for a different day. My concern from a legal perspective is there are certain rights people have with regard to the mask. If I can't wear a mask because I have a health condition, I have asthma, I have some condition that prohibits me from wearing a mask, the employer can't require me to wear the mask. But again, it goes back to what we talked about a little bit ago, is I'm gonna have to provide documentation which indicates that I need a reasonable accommodation. I may need to wear a shield. I may have to work remotely, whatever that accommodation is. I can't wear a mask because of a religious reason. Same factors go into play. An employer may have to accommodate that request. Those are the specific issues that I am concerned with as it pertains to the mask. An employer can't just say, listen, you gotta wear the mask or you have to go home. I don't care what your medical condition is. They may have to accommodate those requests by an employee. They may have to accommodate those issues from an employee perspective. What are some other issues that we are seeing? And again, I'm trying to wrap up so I can get to some of the questions. So we only have 2 more slides. But what are some of the big other issues that we're seeing? Wage and hour issues. If I'm working remotely, how am I being compensated? How is an employer tracking my hours? If I'm a non-exempt employee, an hourly employee, how am I tracking my hours during the day? Because whether I'm working from home or working in the office, if I'm not exempt, I'm entitled to overtime for any hour worked over 40 in a work week. So if I'm working 9 to 5 and then I'm checking emails until 9 o'clock, technically I should be getting paid for that time. So how is an employer tracking my hours? That's one of the bigger issues that we've seen during this time, because no one was prepared for this everybody's working from home issue. Employers need, if they're going to allow people to continue to work from home, there should be a process, a procedure in place to document those hours. Is an employer required to pay the employee if they are laid off or furloughed? Well, there's a difference between a layoff and a furlough. Layoff means I'm terminated, right? I may be called back at some point in time, but there's no guarantee of that. I am separated from employment. A furlough is generally an unpaid leave of absence, where I'm still employed by that company. I may still be entitled to health insurance, I may still be entitled to other benefits, but there's a difference between laid off and furloughed. Laid off is a nice way of saying you're fired, we may call you back, but you're let go. Furloughed is you're still employed and we'll call you back if and when we get work available. How is pay done? Well, for the layoff one, there's no requirement to pay anybody, unless there's a state or policy requirement in your specific handbook, which indicates that I can be paid for accrued and unused paid time off. And if anybody's from California, there are specific laws that provide employees with paid for accrued and unused vacation at the time of separation. So every state has different laws. It also would look to policies and CBAs. That's the termination issue. That's the layoff issue. If I'm furloughed, it's up to the employer with how to handle that. Are you requiring me to use my PTO during this time? Are you not allowing me to use my PTO? And what needs to be done is consistency. It should be consistent and documented how an employer is doing it. If an employer is bringing people back to work, but not all week, all right? We're going to have Ed work 2 days and Mary work 3 days. How are we going to pay me for those days that I'm working and not working? The issue is whether or not I'm exempt or non-exempt. If I'm a non-exempt employee, that means I don't meet one of the criteria to be exempt. I'm an hourly employee. An employer only needs to pay me for the hours that I'm working. So that's simple. If I'm an exempt employee, a salaried employee, I generally need to be paid my salary, my full salary for a week if I work any hours in that week. So if I am told by my company that I need to come in this week and I worked Monday, Tuesday, and then they say, well, you don't have to work Wednesday, Thursday, Friday, go home, they generally still need to pay me for those days, unless there are other circumstances at play, right? If I am disciplined, if I am taking time off, but if my employer is sending me home and I'm able and willing to work, I generally need to be paid for the remainder of that week, my full salary. What an employer can do, cut my pay if I'm a salaried employee, keep me above that 35 and change threshold to keep me exempt, but you can reduce my pay commensurate with what I'm actually working, as long as it's not retroactive, it needs to be prospective. Ed, we're bringing you back to work. When you come back to work, you're only going to be working 3 days, so we're going to cut your pay by 20%. That should be provided in written notice, but that is acceptable. That is something an employer could do. The last thing I'm going to talk about before I take about 10 minutes worth of questions is one of the biggest questions that we've been getting is, if an employee intern gets sick, who's responsible? Who is liable? As a general matter, in my opinion, if somebody gets sick in the workplace, it is a workers' comp issue. It's no different than any other workplace illness or injury. If I contract COVID as a result of me being at work, it's a workers' comp case. The problem is, for me, establishing that I got it at work. Where's the wrinkles? Well, the wrinkles is just wrinkles fall because just because I say it doesn't mean that lawyers aren't suing for negligence. There are wrongful death suits being filed in every state. There are lawsuits being filed in every state against employers that say you didn't protect my brother, my sister, my mom, and as a result of that, they died due to COVID. My defense to that would be it's a workers' comp case. That's an employee realm. What about internships? Well, first you need to look at what the relationship is between the college and the employer. Is there a contractual relationship? If so, is there an indemnification provision? If that intern is not an employee, they may not be covered by workers' comp, depending on state laws, in which case there could be a potential negligence claim. And then it will fall between what's the arrangement between the college and the employer and who is going to be liable. So in a general realm, it's going to be a workers' comp case, but there's that intern wrinkle of if they're not an employee, they may not be covered by workers' comp, and then it may be a negligence claim. As a general theme, that's still going to fall on the employer's shoulders, the company's shoulders, depending on the amount of interaction between the college, university, and the employer. If I'm a college university and I'm sending my students to company ABC and I have full knowledge that company ABC is not doing anything to protect people from COVID, and I keep sending students there and they keep getting sick, well, there may be exposure for that college or university. So it's going to be fact specific. The other issue that keeps coming up is waivers. Can we require interns? Can we require employees to sign waivers to waive claims of COVID-related exposure? You can. In my opinion, they may not be worth the paper they are written on, all right? An employee cannot waive workers' comp cases. That's the area that cannot be waived. Can somebody waive a cause of action for negligence? Yes, they can. But again, it's going to be fact specific. So if you're going to use a waiver for internships, it needs to be very well crafted, but it still may not protect you. The difference between that and patrons, customers, clients, people coming into your business, yeah, you can get waivers for them. It's no different than if you go snow tubing and you have to sign a waiver for that. The primary area where we've seen this are gyms, pools, things along those lines where there's a potential exposure. And in order to gain access to that place, we have to sign a waiver. That's where we've really seen it. I have not recommended to a single client that they have employees sign a waiver because I don't believe they're worth the paper they are written on. You cannot waive a workers' comp case. With that, I'm going to take some questions. Thank you for listening to me talk for the last 52 minutes. I'm going to do my best to answer some of the questions that I've come across during the seminar. Give me 1 second. So we just got a question about waivers. Do we need waivers for students for classroom or activity participation? You work in a university. I do a lot of work for colleges. What we are doing is putting some general language in the return to campus materials that indicates that students understand the risks to coming back to campus and that they understand that they could potentially be exposed to COVID and they are holding harmless and releasing the educational institution from any potential claims. Again, that's different from an employer-employee realm. That would be a negligence claim, so there could be a waiver in that situation. Give me 1 second. Again, if you break your leg and can't start, can you also withdraw an offer? That goes all the way back. My opinion would be yes, right? It's the same situation. If I break my leg and I can't start when I'm supposed to start, I believe that would fall within this realm of what we've discussed with the COVID, right? That if somebody's supposed to start on X day and they can't start their job, well, then maybe the employer may be able to withdraw that offer. Hold on, I'm trying to go through these. A COVID test is part of the pre-employment process, typically paid out of a candidate's pocket. Are there best practices for So would a COVID test as part of a pre-employment process typically paid out of a candidate's pocket? Are there best practices for candidates and companies if testing is required for the job but not easily accessible, available in their state of employment? As a general matter, the test should be paid by the employer, and no different than a drug or alcohol test. If an employer is sending somebody for a drug or alcohol test, the employer is generally picking up that cost. If there's tests are not easily available, again, there's no mandate on an employer to do this. So if tests aren't readily available, it may be difficult to implement this if they need employees to start work or begin their employment, unless they're willing to wait until those tests are available. So again, it's going to be based upon the requirements of the employer, because the employer, again, is the one mandating that this occurs. Can an employee request to telework without pre-existing conditions? For childcare responsibility and caring for loved ones, with a job that previously teleworked 20% of the time, and they were equal productivity when working. And I'm going to try to generalize this one. An employee can request to telework without pre-existing conditions, right? An employee can request whatever they want. It's up to the employer then to decide how they want to handle that situation, and they need to be consistent. Just because there's no pre-existing condition, that takes away the disability aspect of it. It doesn't take away the potential for other discrimination claims. If we're allowing Ed to telework and we don't allow Mary to telework in the same situation, we could have a gender discrimination claim. So yes, an employee can request to telework in that situation. It would be up to the employer to decide whether or not they're going to grant the teleworking situation, and an employer should do so consistently to avoid claims of discrimination. There was a question about the recall letters. May it be sent as email or should be mailed too? This is an easy one. I always request that I always indicate that it should be email or mailed in addition to email. An employee can indicate that they did not get the email, right? If it goes to my personal email, I may not check that every day. If we mail it, preferred certified mail, but not required, then to the last known address, there can be no argument that we did what we could as an employer to get that information to the employee. Hold on one second. Can an employee refuse to work if a dependent has diagnosed medical condition like asthma? And this goes back to what we had discussed probably 45 minutes ago at this point. Yes, an employee can refuse to work if they have a dependent that has a medical condition. Whether or not the employer grants that refusal is a different story, because unless that employee can establish that they need to stay home to care for them and is maybe entitled to FMLA leave, there's no legal requirement unless, again, there's different states and different laws, but there's no generalized law that says I need to be permitted leave to stay home if my child has a medical condition that puts them more at risk. The FFCRA does not apply in that situation. And as a general matter, no federal law has protections. There may be specific state laws. New Jersey has paid sick leave. Different states have paid sick leave that may apply, but it's going to be factually specific. If there's a diagnosed medical condition, the employer tells to go home, but wants the employee to sign a letter to not file unemployment, is that legal? No. In no way, shape, or form can an employer tell an employee that they cannot file for unemployment. That is a right for the employee to do. An employer cannot prohibit somebody from filing for unemployment. If there is an accommodation granted after the pandemic is over and an employee wants to work remotely in the future, does that impact that it was granted during the pandemic, or is it case by case? So again, I'm going to try to rephrase this. So I believe the question is asking, if we've granted somebody to work telework during the pandemic, have we now established a requirement that we do that later? Yes. If we have now determined that this individual can telework due to their medical condition, that may be a required accommodation going forward. So we need, as employers, to be specific that, listen, we are allowing you to telework for the next month. to see where everything is. We're allowing you to telework for the next 2 months, and then we're going to reevaluate. This is not a permanent accommodation because your job does not allow for this to be a permanent accommodation. If that's the concern, we need as an employer to specifically spell out how we are allowing it, when we are allowing it, and when it is going to end. If the employee says my family member has an underlying condition and doesn't want to return to work, does the situation depend if that family member is dependent? I believe I answered that already. How should mask requirements be handled if an individual cannot wear one? Do they need to request an accommodation? Again, an exception. Yes, they need to request an accommodation. If it's a health reason, they would need to provide documentation. Did I say the FFCRA employee applies to only less than 500 employees? Yes, I did. The FFCRA only applies to employers that have less than 500. It is different than the FMLA, the general FMLA, which applies to employers with over 50. This applies to anybody who has less than 500 employees. Do employers in semi-private cubicles have to wear a mask when they're in cubicle space alone? Any guidance on this scenario? This is state specific, right? Pennsylvania, the rules indicate that you have to wear a mask in the workplace unless you are alone in a closed office. A semi-private cubicle is not a closed office. So again, it's going to be state specific. If the state requirements indicate you have to be alone in an office by yourself with nobody else there, that's what we need to comply with. The next question is, will a recording of the webinar be made available? I believe the answer to that is yes. What about if the employee's family member is symptomatic? Does the employer have to tell employees? This would be a contact issue, right? So if an employee has a contact, is exposed to COVID through a contact situation, and there's a probable case in the place of employment, then that may trigger the requirement to inform employees that this employee is out, that we had an employee exposed to COVID. We are notifying you of that fact. All right, so that may trigger the requirement depending on the circumstances. If the staff is only 2, this is a question that we keep getting, and I'm going to give you the best answer I can, right? A lot of companies are small, and if I test positive for COVID, my coworkers are going to know it's me. If the employer says somebody tested positive for COVID, we're letting you know. If they can figure it out, they can figure it out. An employer has a responsibility to do what they can to protect the confidentiality of that information. We cannot say Ed has COVID, or Brian, or Bill, or Bob, or Mary, or Sue. We have to do our best to comply with this, with those confidentiality requirements. And if an employee can figure it out, we've done what we can to protect that information. What if the internship is unpaid? Is it still workers' comp? It's state specific. Different states have different requirements. I believe Florida indicates even if they're unpaid, an internship may be covered by workers' comp. You would have to look at your state specific laws to determine whether or not the workers' comp would apply in that situation. And I believe we're after 12. I think I answered the majority of the questions that we had here. I appreciate everybody for attending. If there's additional questions that you would like answers to, feel reach out to NACE or send them to NACE, and we may be able to provide to do an additional follow-up article. We also have a blog that's identified here, that the web address is here. We are doing our best to update everyone on a daily basis of changes, but there's a lot of information about COVID and employer responsibilities and employee rights on that blog. It's not just state specific. There's a lot of state specific stuff included in it, but there's also general requirements that everyone is facing at this point in time. So with that, I want to thank everyone for attending. Stay healthy, stay safe, and good luck with handling all of these issues as you go forward.
Ed, thank you very much for a very informative session. And thank you to our participants for attending today's session. This officially concludes the webinar, and you may now sign off. Thank you.